Well, welcome everybody. Good evening and welcome to this evening's meeting of the Guildford and Waverley Joint Standards Committee. I'm Councillor Andy MacLeod, and one of my co-chairs, and seated at my left is Councillor Joanne Shaw from Guildford Borough Council, who is the other co-chair. Before we begin, I have a few housekeeping comments to make. May I ask everyone to switch your mobile phones and handheld devices to silent for the duration of the meeting. If the fire alarm sounds at any time during the meeting, we are not expecting it to go off, except in the council chamber. Everyone in the council chamber should leave immediately through the nearest fire exits and proceed calmly to the assembling point in the fields adjacent to the main car park. Before the Joint Committee considers the business on the agenda this evening, I would like to remind everyone that by participating in the meeting, you are consenting to being filmed and recorded, and the possible use of these images and sound recordings for webcasting and for training purposes. Although the meeting is being recorded, anyone is permitted to record the proceeding on their own devices, for example, for social media purposes, provided they do not disrupt the meeting by doing so. If you're attending remotely, may I ask that your cameras and microphones are turned off at all times during the meeting and only switch them on when you're invited to speak. For your own privacy, camera background should be blurred. Any non-committee members or officers who are attending remotely and who wish to speak on any item should indicate this by leaving a request on the meeting chat box. Right, I think that's all the introductory stuff. Kimberly, can you report any apologies and notifications of any substitutes, please?
Thank you, Chair. We have apologies from Joan Hegan, Julia Osborne, Councillor John Rabini, and Councillor Fiona White, and Councillor George Potter is attending as substitute for Councillor White. We also have Councillor Ruth Rothwell, who's not in attendance, so we will make a presumption there is apologies from her as well. Thank you.
Thank you. May I ask members of, this is to do with declarations of interest. May I ask members of the Joint Committee whether they have any declaration of interest in relation to any item included in the agenda for this meeting in accordance with the Constitution, with the Council's Code of Conduct. Any declarations? No? Thank you. Oh, George, you have your declaration.
Well, just to clear, I mean, presumably we all have an interest in this as members of the council, but presumably it's any particular personal interest in it beyond the simple, the general one. Because if that's the case, no, I don't have any, but I just wanted to clarify, because I imagine we all have some interest in this.
That's correct, George. Thank you. Item 3 is the minutes. Is the Joint Standards Committee happy to confirm as a correct record the minutes of our first meeting on 9th December 2025? Is this agreed?
You're allowed to light your ship your light.
Yeah, I was actually present. I know I'm very shy, retiring councillor, but I was actually there, and I'm actually a member of the committee.
It's not recorded in the minutes. In other words, we'll make sure that is corrected, Steve. I think it's because you're a new member of the committee. So probably,
yeah, I imagine that's the reason. Yeah, thanks.
Can you hear us, Faith?
No, she's just sitting there.
Oh.
I'll just put something in the chat, yeah.
Hello members, just to let you know, sorry it's Katie Maxwell here, just to let you know we did lose sound We have lost sound for a period of time. I don't know if you can hear me at all.
We can hear you now, Katie. We can hear you.
Okay. We lost sound for a moment then, so we weren't listening, so Faith may not have heard.
Hello, Faith, can you hear us?
Yes, I can hear you, but you had gone silent. Sorry.
Okay.
Thank you.
Okay, good you can hear us, Faith. Can you now introduce item 6 for the
Oh,
committee?
apologies. The report is just formally recording the constitutional updates that have been made by the monitoring officer. Majority of them are in reflection to the council decisions in October and December. One, to form the new joint committees, so the joint exec, the joint standards, and the joint overview and scrutiny, and also to establish the West Surrey Joint Committee. These other minor constitutional amendments which are required predominantly to make corrections of errors, to reflect any operational change, any recent job title change, new post, or any other decisions that have been necessitated by consequential changes throughout the Constitution. So Appendix 1 sets out a list of this proposed changes, which have, the list of the changes that the monitoring office has undertaken. So part 1, in the summary, we've had references to the new committees. Article 7 has included specific reference to the new Joint Executive Committee. Article 8 to the Joint Overview and Scrutiny Committee. Article 9 to the new Joint Standards Committee. There's been amendments to Article 13 in relation to aligning with existing contract procedure rules. There's also been some changes to legal proceeding to reflect advice we've received from the local government lawyer. There's been references throughout all of part 2 in the articles, either to cross-reference, to ensure consistency across the Constitution and to avoid any procedural ambiguity, and just to reflect the formal powers and responsibilities either approved by full council, including anything to do with the new LGR functions. There's been amendments to part 3. These have been predominantly in relation to the new procedure rules, the new joint procedure rules for either the exec, the procedure rules for the new joint ONS. There's been amendments to part 4, which sets out the decision-making rules in relation to the bodies and the new committees. There's also been updates throughout the Constitution in all parts, either correcting spellings, formatting, cross-referencing. So it's just been a general overhaul of the Constitution, and that's going to be for both. That's for both Guildford and for Waverley. So and also we've taken that opportunity to make some minor alignments as part of the corrections and the formatting. Thank you.
Thank you for that, Faith. I'm happy to propose that the Joint Standards Committee approves the recommendation in respect of this matter, which is set out in pages 10 and 11 of your agenda. May I ask the co-chair, Councillor Joanne Shaw, to second the motion, please?
Yeah.
Councillor Potter wishes to speak first. Do you not have debate on the report?
Sorry?
Do you not have debate on the report?
You do shortly. That we've got a very set procedure to go through, George, which is set out for us, so we have to do it that way. We do have the opportunity to ask questions and have a debate. So,
yes, I second this and reserve my right.
Thank you. May I ask for any comments or questions from any non-members of the committee? Are there any? None available. Thank you. Now may I ask any members of the Joint Standards Committee to if we wish to comment, ask a question in respect to this item. George.
Yes, with apologies, Chair, because obviously I'm substituting, so I did not have a chance to read the papers until today. However, we've got a covering report for this item, sort of giving a summary as to why they're there. We then have an Appendix 1, which contains a schedule, but which just simply gives sort of a description of the amendments and reasons why. What we don't have is the specific wording of the changes. All we appear to have is a link to the constitutions on the website, which presumably reflect the changes, but we don't appear to have any document explaining what has the actual wording changes that have taken place.
Within the papers are actually complete copies of the new amended constitution. So if you look further in the papers, you'll find complete copies, if I'm correct in saying that. Am I correct? saying that?
I don't think so.
I thought we had, well, certainly online, I thought I saw that actually.
If-
Sorry? Could Faith respond please to counter?
Yes, so the current papers are only to notify of the changes we've made. They're not complete. For us to do that, we would need to produce a complete republication of the Constitution as part of the papers. What we will do is we'll provide a link of all the changes, and if members are minded, we can also provide a complete. It's over 450 pages of the old version and what the proposed changes that have been made under delegated authority are, or what the changes are that are being made.
If I may, thank you. When we've had constitutional updates come before committees like this before, what typically happens is you receive an accompanying a tracked version of the changes, showing sort of the document with the tracked changes as well as a clean copy. If this is, I appreciate that these changes have already been made under delegated authority, and this is simply to notify us. But when we have, for example, wording saying sort of for instance, update the scheme of delegation, or to update Article 13 in respect of legal proceeded to reflect advice to all councils from the local government lawyer, I think the committee needs to be able to see what those changes actually are, not simply just sort of get a single one sentence summary of what the changes are. I think we need to be able to see specifics in order to give any kind of judgment on it. So personally speaking, I'm not sure I can support the recommendation without having seen what the actual changes are. And I'm not necessarily asking for a physical printed out copy, but we've had digital copies of the changes in the past. It doesn't have to be the whole document, only the bits that have changed. I'm not really comfortable making a conclusion on this without having seen those. I'm quite surprised we don't have that, but I'll let other people speak. Thank you.
Would you like to respond again to that?
Yes.
Sorry, I think I misunderstood actually. In the electronic version was a link to the both councils' constitution.
But
I must admit, I assumed that the constitution had been updated within these links. Maybe I was wrong.
well, sorry, just to be clear, we have a link to the updated constitutions, but being able to see the current constitution doesn't help you understand the changes if you cannot see the previous version to do a comparison. So
okay.
that, I find that unsatisfactory. So
could you respond now, Faith?
Yes. So, for example, on Article 13, the word is "and any delegated person." It's a single insertion, so it's a minor consequential amendment and would not normally have been brought to committee as a whole report. What we've done is we've taken this opportunity to note all the changes that we're making. There's been changes, for example, changes of job titles that have been throughout the Constitution. If members are minded, and I'm sure Deborah is on the line, should be happy to confirm, we are happy to share a copy of the changes that have been made through delegated authority, because this delegation has already been given to the monitoring officer to make these changes. We're just notifying the committee, mainly for transparency and for completeness. And I appreciate your comments, and I'm happy to take that feedback back and make sure that before the report goes to council, that the full version of the track changes is presented to council when it goes before both councils as required.
Yeah, please.
Chair, Deborah Davis is on the line and she'd like to respond to this, please.
Please do respond, Deborah.
Thank you, Chair. So if I could just chip in. This is a report for noting, and I absolutely do accept that members can't see the changes. And for the future, we will make sure that we send you an electronic version so you can see the before and after. But we're not asking you to agree the changes. We're asking you to note that we've already made those changes.
Thank you for that. Anybody else wish to comment? No?
So, unless I'm mistaken, I think this has already been through JCRG, has it not? In which case we have done that line by line analysis in the working group.
We did talk through it. Yeah, that's correct. Yeah, the changes were all discussed. That's correct. Yes. Again, George.
Yes, I'm sorry, Chair. I'll be honest. I'm a bit frustrated with the way in which this meeting is being run, because if this has been for the GCRG who has reviewed this, and I presume that members of the JCRG are here at this meeting, if they are able to say that yes, they've confirmed these, yes, they've got no objections to them, I'm willing to note it. Although I do think, as a matter of record, there's not much point in asking this committee to note anything if the actual text of what we're being asked to note isn't being presented to us. If we effectively just, I'm happy to note that the JCRG has reviewed these and is satisfied with them. But I think from a public transparency point of view, if the actual changes are not being published in the papers of this meeting, then what's the point of having this item? Because we're not actually providing any public transparency or accountability. And, you know, and I'm, you know, I think a better managed meeting would be, you know, dealing with that in some form, even if it's just simply to say that actually this has been dealt with elsewhere, so it's already in the public domain. But I don't see the point of having a paper asking us to note something and to then not provide the specifics for us to note. It just seems like a complete waste of time to have this item here. But if the JCRG members are here, and if they can confirm that they've reviewed these line by line, they're happy with them, then great, I can take some confidence from that. But I don't see what value we're adding as a committee if we're not looking at the actual changes ourselves to note them.
Well, I think most of the JCRG members are actually here. Jem.
My apologies, it's a misremembering. I've just found the reference, it's on page 12. They've actually gone through each of the execs. So I knew I'd seen them before. It was exec, not JCRG. So they have been reviewed.
Co-chair.
Sorry, sorry, I just want to clarify something. On page 12, what it says, if I'm correct if I'm wrong, what it says there is that the establishment of the West Surrey Joint Committee has gone through both the Joint Executive and both councils. That, I'm sure we all remember that being passed. But that's not the only item we have here. We also have a variety of described but specific missing set of tidying up changes made under delegated authority by officers. From my point of view, if a change is being made under delegated authority by officers, surely the point of it coming to this committee is so that we, on behalf of the public, can be satisfied that the delegated authority is being exercised in an appropriate way. So unless there's somewhere where these specific changes have been put into the public domain, I don't see how we are doing our duty as a standards committee if we just wave this through and say, yeah, we're happy to note them, but we've not actually seen the things we're meant to be noting. I'm happy to accept that we've seen the West Surrey Joint Committee changes. Those have gone through both councils, but that doesn't apply to everything else in the report, that the report alludes to. Well, I don't think, again, if somebody's seen these somewhere, they're in the public domain, that you can refer me to, then great. But if not, how can we be expected to note these? And I think it's important to be accurate about what has and hasn't been put in the public domain.
On the first point you made, George, I think delegated authority is delegated authority. It doesn't have to be approved by anybody.
No, I'm sorry, Chair, that is a complete and, I'll be honest, grotesque misunderstanding, not just of the Constitution,
Well,
and also of your role as a councillor. The whole point about delegated authority is when it is exercised, decision notices are published, which enables councillors under our constitutions to review or to call in or what have you, to provide some form of oversight, because those authorities are being exercised in the name of a council. There's nothing suspicious or wrong about those authorities being exercised, but we are here as a committee, as councillors, to provide the ultimate democratic accountability for that. So it's perfectly fine for delegated authority to be used and for it to be published somewhere as a record so the councillors can look at it, and if we're not happy, we can say we're unhappy with it. But we can't do that when the details of a delegation and how it's being used are not being provided. It's perfectly fine if an officer uses delegated authority to award a contract for a procurement contract. That's fine, as long as the decision notice is published, so we can review it and raise concerns if you have any concerns. But for you as chair of this committee to sit there and say, well, it's delegated authority, so it's all fine, is, I think, an abdication of your
Can I say,
responsibility.
George, I'm not a lawyer, actually. I was giving a fairly amateur opinion. Fortunately, we've got a lawyer here, maybe Councillor Goodrich could help me. But certainly in terms of planning matters, where I'm on a planning committee, a lot of planning decisions are taken by the officers, and they never come before the planning committee. And my understanding then is that in that sense, I wasn't commenting on delegated authority in every respect. I wonder if Councillor Goodrich could help me here, because he's a lawyer and perhaps he could, I'd welcome his comment.
Chairman, I may be a lawyer, but I've never in the 20-something years or 30 years I've been on the council advised the council on law. I leave it to our officers.
Lawyer.
I am a lawyer and a member of the corporate governance team. And my advice to the chairman and the committee in response to Councillor Potter's points is, firstly, that not all delegated decisions are published. You have various types of decisions. Something like what's known as an administrative decision, you wouldn't publish. There's no requirement to publish that. And the point that Faith and Deborah have been making is that most of these changes are minor in nature. They are administrative. They are things that the monitoring officer would do on a very regular basis to tidy up the constitution and sort out any inconsistencies. That would be my first point. My second point would be, my advice is, if Councillor Potter has an issue with how the matter's being presented, this forum is not the place to challenge that. Members are just being asked to note the changes that have been made. The fact is that we have relied on delegated authority to make those changes. I think there are other mechanisms by which, if you're unhappy, should the vote go ahead, for that to be challenged. But the point is that these are made under delegated powers. Officers have brought to your attention everything to the extent that they think you need to see it to be able to make the decision, and the decision is just for noting. So my advice would be that if you wish to, members can proceed to the recommendation. If Councillor Potter has concerns about that, I think there are other ways to raise those. Well, you can take it to the monitoring officer, because it is her exercise of her delegated authority. So I think the starting point would be that that's for you to raise with her and understand her justification for dealing with the changes in the way that they're being dealt with.
What does the scheme of delegation say about how that delegated authority should be exercised in terms of reporting and transparency?
To my knowledge, off the top of my head, I can check if that becomes necessary. But of course, the Constitution then is published. So all of these amendments are made. We're saying that they're relatively, minor, or they've been approved elsewhere. That Constitution then has to be published. That's a statutory requirement. So then everyone will be able to see the changes that have been made.
How can you see the changes being made if all you have published is the new version? Sure, you need to be able to see the old version at a minimum to be able to do a comparison between them.
Well, I understand what you're saying, Councillor Potter, in terms of often when we bring changes to you, we have a comparison. But the point is, the monitoring officer has a delegated authority to make the changes, and then she's legally obliged to publish an up-to-date version of the Constitution. So in terms of people understanding what our Constitution is and what the rules require, they can see what the current state of play is. I think what you're saying is you wanted to be able to take a view on whether any particular change was a good change or not. But the point is that that's not a matter for the members of this committee when the monitoring officer is exercising her delegated authority.
With respect, the point about delegated authority is that some things are within scope of delegation. So, for instance, tidying up a spelling error is within the scope of delegation. To change the Constitution to delete an entire committee, for example, is not within the scope of delegation. If we are not able to see what has been changed under the scheme of delegation, then how can anybody judge whether or not the scheme of delegation is being followed or not? Effectively, what you're saying is that the monitoring officer has the power to make changes. We have to trust that the monitoring officers making changes correctly. We don't need to see what changes they're making because we should take their word for it. I'm sure that cannot be how our constitution is set up for that delegated authority to work. That doesn't make sense.
You wanted to speak, Stu?
Just briefly, I can understand totally the point that Councillor Potter is making, and in a sense, I do feel uncomfortable personally in noting changes and where I haven't actually seen the changes themselves. I can completely go with that. What I would propose would be that we note the changes as in the recommendation, but that we record in the minutes the request to circulate an annotated copy of those changes to members of this committee subsequent to this meeting, so that any matters that actually do appear to go beyond the realm of delegation, or about which we might have concerns, could be raised under matters arising at a subsequent meeting of this committee.
Thanks for that comment.
Can I come in, please?
I think Deborah would like to come in again, please.
Thank you, Chair. And actually, really, I was just going to say what Councillor Williams has helpfully said, that we will send round a copy of the Constitution to members, and clearly for the future we will make sure that we include the annotated copy, or at least a link to the annotated copy. We clearly don't want to be publishing 450 pages for members unnecessarily, but we will send you a link for the future when we bring constitutional changes forward. But as for Councillor Potter's point about, well, the monitoring officer could have deleted a whole section that she didn't have authority to do, we have set out in the table the amendments that we have made. Clearly, we haven't provided you with those amendments, but hopefully that gives you the comfort that we have only limited the amendments to those areas that members have already considered.
Thanks for that, Deborah. Are you happy with that, George? Okay, that's good.
Is that not subject to what Councillor Williams suggested? I believe Councillor Williams suggested that we also note in the minutes something. Is that, are we agreeing on that as well, or are we just going back to the wording of the recommendation?
No, we'll agree to that as well, George. Yeah?
Can you ask the room chair that can we just confirm that all members have agreed to that?
Yeah. I've just asked, can we confirm that all members agree to that?
Yes, agree.
All agree. Thank you.
Deputy Manager. Agreed.
Chairman, I think it would be for the benefit of clarity, can we just ask members to confirm that on the substantive motion to note, as per the recommendations on 10 and 11, that they're in agreement? Subject to the cap. Yes, subject to that. Yeah.
Have we all agreed to that? Good.
Thank you.
Agreed. Good. Right, I think that finishes item 6. So moving on to item 7. Statutory Officer Disciplinary Policy and Procedure. May I ask Angela Watson, Joint Senior Solicitor, Corporate Governance, to just introduce this item to the Joint Committee. Thanks, Angela.
Chairman. So, yes, good evening, members. I'm sure many of you will be aware that certain senior local authority officers are afforded additional statutory protection in the event that disciplinary action is needed to be taken against them. The officers concerned are the paid service, that's our Chief Executive Officer, the Chief Financial Officer, which is our Section 151 officer, and the Monitoring Officer. And also in our 2 councils, it applies to the Joint Strategic Directors and the Joint Assistant Directors. Most of the additional statutory measures apply to the 3 statutory officers, and include use of an independent panel, consultation with the executive, and the dismissal being approved by full council. The purpose of the report before you this evening, as it relates to disciplinary action against the 3 statutory officers, is to put forward a more detailed policy and procedures than those currently set out in the existing officer employment procedure rules. As it relates to those 3 statutory officers plus the joint strategic directors, it is to recommend that a joint appeals panel be established, and that would be to hear appeals from the 3 statutory officers against action short of dismissal, and from the joint strategic directors against dismissal or any action short of dismissal. The report sets out that there be required amendments to Waverley Borough Council's constitution, which currently does make provision for its own appeals panel and independent panel. The amendments also are required to the existing officer employment procedure rules. The recommendations also request delegation to the monitoring officer to work out terms of reference for the joint appeals panel and the independent panel. And those terms of reference would be presented to the next full council meeting. And then if the committee is happy with the principle of establishing a joint appeals panel, I'd just like members to note that 2 further minor amendments will be needed to section 461 of the officer employment procedure rules and to section 13.2 of the policy. This report and the draft policy went through the last meeting of the joint constitutional review group, and I picked up in this report a couple of points that arose there. In particular, we're suggesting that the joint assistant director people is the initial point of contact when a complaint is first submitted, and also has a sort of primary role in the initial validation and any issue of urgent suspension. There was a discussion at JCRG sort of along the lines of, well, of course, all 3 officers could be subject to complaint at the same time, and how would that work in practice? So the policy tries to reflect that, giving the, as I say, the joint assistant director people a lead role, and along with the leader being able to just go to externally if you needed that resource, because all 3 officers were involved. Also there's the issue of, well, what if the monitoring officer is involved? Because currently there's quite a role for the MO, obviously, in terms of things like sourcing, the investigating officer, convening the appeals panel or the independent panel. So now the suggestion is that that would fall to the deputy monitoring officers. I think one comment I had in response to the consultation was, well, would those deputy MOs be happy to step into that role if that were needed? But I think my point would be that they are already existing senior officers, well versed in sort of dealing with confidential and sensitive matters. So in the event that the MO was involved and there was no one else that could step into the breach, the DMOs could fulfill that role. But I'll leave that there, Chairman. Hopefully that sets the sort of context of the report, and obviously happy to take any questions. Thank you.
Thank you, Andrea. I'm happy to propose that the Joint Standards Committee approves the recommendation in respect to this matter, which is set out in pages 20 and 21 of our agenda. May I ask the other co-chair, Councillor Joanne Shaw, to second the motion, please?
Thank you. I second the motion and reserve my right.
Thank you. You have noted that there is also a separate additional recommendation to Waverley Borough Council that it agrees to remove from its constitution the terms of reference for the appeals panel, including those for the independent panel. Waverley members of the Joint Committee will take a separate vote on that recommendation later. May I now ask whether any non-members of the Joint Committee from either council wishes to comment or to ask a question on this item? None. Okay. We now invite members of the committee to speak or to make comments or ask questions, please.
Thank you, Mr. Chairman. First of all, I'd like to congratulate Angela on the awards. I unfortunately have had to sit on an independent panel with trying to decide the fate of one of these individuals, and this would have certainly helped. The only real comment I have is on page 34, 4.1, and it's a personal bee in my bonnet that I have on any public related documents. The wording is, it is recognised that it would be inappropriate to impose timescales that could in practical terms be difficult to achieve. Well, I think there should be some timescales for an individual whose career could be hanging by a very thin thread to say, oh, we'll deal with it, you know, in a vague, wishy-washy way. Let's at least have some backstop in there within 3 months, within 6 months. I'm not fussed. But I don't agree that it would be inappropriate. I think it is appropriate. People want justice and they want it swiftly. They don't want it hanging around their neck. These are serious individuals in the public sector, and it's their reputation as well as their career that could be at stake. So I would just throw that in as the independent person.
Comment. Can I ask Angela to respond first before we take further questions? Or would you like to comment first, Joan?
Yes, please, if that's okay. I do appreciate what you're saying, and I think it's perhaps down to interpretation, because it does go on to say, however, an important principle when taking action under disciplinary procedures is that the process should be conducted expeditiously but fairly. It's not in the interests of the councils or the statutory officer that proceedings are unnecessarily delayed. So I don't know, is that too vague or? Yes. Okay.
To be quite blunt, yes, it's too vague. It's typical legal wishy-washiness. Let's tie it down. If it's 6 months, so be it. I'm not wedded to any timescale, but I think there needs to be something in there, because one man's rapid justice is, well, I wanted it done tomorrow. You know, let's be reasonable about this, but I think there needs to be some sort of months in there somewhere.
Anyone else want to comment before Angela comes in? Angela.
I was going to make a similar observation to Councillor Shaw, and of course one of the difficulties is that there's lots of moving parts, and some of it we're relying on external input, so that can make it difficult. It's how quickly can we get the investigator on board if it needs to be, how quickly can we convene the independent panel. So some of those things could make achieving timescales difficult, but I was also going to make the observation that I hope the document does reflect the seriousness of the process, the fact that it's in no one's interest for it to be protracted. And I think also I'm conscious that, you know, for instance, at 311, if the officers were suspended, there's a provision about suspension being reviewed after 3 months. So there are sort of a couple of other triggers whereby you might start saying, oh, this is taking a while and reviewing it. So, but I'm very happy to go away and think about and maybe sort of have a look and see if there's anything that can be done to. So I think, to answer your question, one backstop I think is the 3 months suspension, that if you get to that point you should review. That possibly is the only one in there at the moment. But yes, I think you'd have to then think, and what if you get to the 6 months? If we were to put that backstop in there, if we get to that, what happens then? Who's, you know, it could be that ultimately the JSSC just has to review everything and say, we realise it's taken to this point, but these are the reasons for that, and, you know, we carry on. Or
all parties are made aware and are kept updated, then they're quite happy to allow things to slip. But at least if there's some targets we are aiming, you've said can be reviewed after 3 months. Well, we're aiming to achieve this to be resolved in 6 months, say. And if it's not resolved after 5.5 months, we need another 2 months. I don't think anybody's going to be too concerned, providing there's You know, we're getting on with this. We really are. And there are some dates in the calendar that we can all look at.
Let's have your comments, George.
Thank you. First of all, just say I think it's very helpful to have a tracked copy of changes on this one, which makes the conversation a lot easier. I think my perspective on this is, in my day job, aside from other things, I am a union representative in my workplace, and I've had to deal with my fair share of disciplinary cases and that sort of thing. I can see sort of a case on both sides here, and I think one thing we have to bear in mind is that the gamut of things covered by this procedure is everything from sort of items which are very clear cut and easy to resolve, all the way to issues which might be incredibly difficult and time consuming to investigate and resolve. And I think I'm reticent to put any kind I'd be concerned about any kind of arbitrary time threshold or cutoff. I can see the desire for it, and I think it's worth noting that in a lot of high profile employment tribunals where a public body has lost the tribunal, it often comes down to that they have dragged their feet in handling the process, and as a result, even if the grievance was justified in the first place, the way in which proceedings have been handled ends up resulting in the public body losing the case. However, by the same token, I'm not sure it's possible to come up with a set of time thresholds which are appropriate or proportionate for every case. And nor do I think it's necessarily appropriate to have something where you can say, well, by mutual agreement, this can be extended. Because for some things, 3 months might be too long to resolve it. For other things, a year might barely be sufficient because we're covering a very wide range. And even though I tend to err on the side of I want employees to have as much protection and justice and process as possible in a situation like this, I'm not sure you can come up with a form of wording which will cover all circumstances. And I think for positions this senior, with the potential nature of things which could come up to be dealt with under this procedure, I think it is probably better to err on the side of giving of an open-ended timescale. But I would hope that the council and the HR professionals in the council would be mindful of the fact that justice delayed excessively is one of the biggest reasons why otherwise sound decisions end up being lost at employment tribunal. But ultimately that comes down to do we trust the professionalism of our HR teams, our legal teams or not? I think we have to, because I think we'll turn to this to try to bind their hands. And I think it's also worth noting that given the very limited number of roles impacted by this procedure, and we are talking here about the most senior, most highly paid, most well-resourced members of the staff at the council, this is probably the group, if there's any group where we need to err on the side of giving the council more leeway as an institution to deal with things, it's in this case. If we're talking about ordinary rank and file employees, I'd be more inclined to go with Mr. Litvak's assessment. But in this case, I'm not sure whether it is appropriate for us to unduly bind the hands, because I think there is an overriding thing of if the council takes too long to deal with something, then it will be held liable at a later stage anyway by an employment tribunal. And I think we have to have I think it's better to put our faith in the system in that regard than it is to try to come up with an arbitrary timescale, because I do reiterate, I think that any arbitrary timescale or backs that we could come up with would not be appropriate for all situations. And I'm not sure I can think of personally any form of wording which would both be not too long in some cases and not too little in other cases. And I'm not sure that there's any form of discretion you can apply where it's say agreement on both parties, which doesn't make it vulnerable to a bad actor. I think ultimately we just have to apply some trust in this case, and but that's just my take on it. Thank you.
George. Mike.
I think I agree entirely with what Councillor Potter has just said. I wonder if it might assist if we had the review after 3 months and then maybe every 6 weeks thereafter, just so that it's not slipping without repeated attention.
Michael, you wish to speak?
Yes, a different point, if I might, Mr. Chairman. I was sort of rereading these papers, and particularly paragraph on page 41 or 45, whichever it is, 12.2 on the dealing with appeals, where a dismissal is proposed. It says in 12.2, it will not be appropriate for Waverley Borough Council, full council, to undertake a full rehearing of the case. But then it goes on to say the statutory officer's appeal against the proposal to dismiss in this section will be at this stage as well. How can a senior officer appeal against a decision if you don't review the facts? I mean, from a practical point of view, I'm not quite sure how the senior officer's appeal can be heard by full council if full council cannot review the the hearing of the case. In other words, what facts were there, and are they? I'm worried about the practicalities of it. And I have another point which I'll raise now just for clarification. We refer in 13.2 to Waverley Borough Council's appeal panel. There's also talk about changing the terms of reference of it, and there's also talking about a joint appeals panel. I'd just like to understand how they work, and in particular, has Waverley actually got an appeals panel? I used to be on it for years, but I don't know if it still exists.
Thank you, Chairman. I'll start with the last point first. So yes, 13.2 is one of the additional amendments I would need to make if members wish to go with the idea of a joint appeals panel. Waverley currently does have terms of reference for an appeals panel, but my understanding is it hasn't been appointed to for several years, hasn't been needed. So the idea is that we'd remove that and we would have a joint appeals panel instead. So there would need to be an amendment to 13.2 if that's what members are happy with. The point about rehearing and the right of appeal, the role of full council is to consider the JSSC's proposal that dismissal is the right course of action. I think the thing to remember is that before you get to the full council meeting, there will have been 3 meetings of the Joint Senior Staffing Committee, and at every stage, the officer concerned is entitled to come along to make representations. And so the facts will have been established by the JSSC, and indeed that's the role of the JSSC. They are the investigating and disciplinary body. So that process has already been undertaken, and full council, it's a review of, and then having undertaken that process, they've obviously formed the view that dismissal is the correct course of action. So when it gets to full council, it's a review really of JSSC's decision. They're not there to establish the facts of what has gone on. And I think from members, and I just say that this is the standard process, but from members' point of view, you can be clear that that has been tested in a way in 3 stages. We've also had the report of an independent investigator. We'll have had the independent panel looking at it. So the facts are already established, and it's for the JSSC to take a view on that, not the full council. So that's that point. And just coming back to the timescales, the only other thing I was mulling over was whether we try and say, because obviously we have validation of the complaint, and it's either accepted as valid or it isn't, and then you get to the initial assessment committee meeting. So I was sort of wondering whether it's feasible to say, if we at least accept a complaint as valid, we try and hold that initial meeting within a certain timescale, because sort of once that's held and kicked off, everything else sort of flows from it. But then I'm sat here trying to think what an appropriate timescale would be, because it can take a while possibly for the validation to take place. But we could be thinking, well, that within a month of it being accepted that it's a valid complaint, something along those lines. Chair.
Just another thought on that point is that perhaps at the point that the complaint is validated, by that point we'll obviously know, or the person validating the complaint will know the detail of it and will be able potentially to triage it and to work out this is a very simple case that's not going to require lots of witnesses, or this is a really complex case that potentially involves lots and lots of officers within the council and is going to take a lot of time. So it might be possible to say, as part of that triage, could we then set some timescales?
It's something I can look at. I think we'd have to caveat that, because I think we talked about the JCRG, it could be there's a criminal investigation that, and that's going to throw all of this out of kilter. So subject to some caveats, I think we could go away and think about, how that might work.
Yeah, I was going to say two things. I think the first thing is that I think on that point, I mean, perhaps some wording setting it sort of, they should, at an appropriate point, they should set out a likely timetable for the investigation and the procedural handling, because I think at least that way the subject of the complaint knows what to expect effectively. So I think that might, I mean, you'd have to come up with an appropriate legal form of wording, but I think a likely time scale, not necessarily setting it in stone, but certainly setting out what it should reasonably be. But I think the other point to make is, but I think on that point about the appeal at full council, so just to make sure I've understood this correctly, so effectively what would happen is, to take a hypothetical, say there's been a complaint of bullying against, say, the chief executive of the council, as an example. That would go through the independent panel. The joint senior staffing committee would then have to would meet 3 times. That would, they'd have meeting papers, all the rest of it. They would come to a conclusion about what should happen. That conclusion would then be brought to a full council meeting. At the full council meeting, the point of when the council is the final appeal, what that's effectively there is it's the ultimate point where the council can either ratify or overturn the joint senior staffing committee's decision. But what it shouldn't be doing at that council meeting is to be relitigating all the detail of what happened in the investigation and the case. It's about simply saying either we support the conclusion or we're overturning the conclusion. So, but for instance, it's not a place, it would not be appropriate if there's, say, a bullying investigation for the details of the bullying, the ins and outs of who said what and when, to be debated again at full council. It's more do we agree with the joint senior staffing committee's conclusion on whether or not bullying took place and of their conclusion on appropriate sanction. Is that correct?
Yes, the point is it's not the fact-finding body. So you've gone through all the stages to establish the facts. It's just that, yes, it's not a full rehearing in the sense of trying to re-establish the facts, but that's already happened.
Going back to Ms. Wood there, who started the whole thing off, your basic concern was about fairness, wasn't it? That the whole process be fair. Do you feel this discussion has helped, and are we moved towards anything that Angela can do to the wording to make it better?
Yes, I mean, I'm not a wordsmith. I am quite relaxed about the actual words. I'm delighted that Angela's already sort of seeing the wood from the tree, so to speak. I just feel, because I've sat on that panel, and it's not pleasant.
No, you've seen it in practice.
I've seen it in practice, and in my opinion, it took far too long. And no one was at fault, but when they could have dealt with it today, oh, we'll have another cup of coffee and we'll deal with it tomorrow. And days rolled on and days became weeks. That's my concern.
Sorry, Michael.
Yes, on the appeal point, sort of converting it to sort of criminal proceedings. Basically, we're not appealing against the conviction, we're appealing against the sentence. So it's really we take the facts as read, and it's a question of whether the full council agrees to the outcome of what should happen. So does the senior officer have any right of appeal against the facts at any stage?
Appeal might not be the right, but obviously they are entitled to present their case all the way along. They're entitled to bring evidence, call witnesses, etc., etc. So there is that process. that they can fully participate in when it comes to establishing what the facts are. So they have lots of opportunity to do that, but then ultimately it'll be for JSSC to decide what it believes the facts are.
So in effect, there's no appeal against the JSSC, or whatever it's called, conclusion on the facts. If they decide on it, I mean, in any trial or civil case, both parties have ample opportunity of saying what they want to say, and then judge comes up with a conclusion. And in effect, that committee is the one who comes to the conclusion, but there's no appeal from that as to the conclusion.
If I may.
Is there?
I would just say we need to remember there's the involvement of the independent investigator, and that's a very important safeguard, and that's one of the statutory safeguards, probably to guard against that very concern. So we hand it over to an independent investigator to establish the facts, and the person who's been complained about is fully entitled to be involved in that process and present their case to the investigator.
Gemma.
Thank you, Chair. I was just noting that in the middle of that, the chairperson of the JSCC will attend and present the proposal to dismiss and reasons for it. So presumably, if those reasons were completely contrary, the employee would have rights to appeal on the basis that it was a, Wednesbury reasonableness type of
I
position.
think if the conclusions were completely sort of, contrary to sense, we'd find ourselves at an employment tribunal pretty darn quickly, which is obviously what, no one wants. Hence the involvement of the investigator and the independent panel. They're all mechanisms by which we're trying to get to, obviously, a reasoned, fair and truthful position, account of what has gone on.
If I may, I mean, I think a useful analogy here to consider is a civil proceeding, like say libel, so somebody being sued for libel. If a ruling is made by a judge that in a civil case that libel has been committed or libel hasn't been committed, either party has the right of appeal to another judge, but the next stage of the Court of Appeal is not there to reevaluate the facts of the entire case. It's there to consider whether or not the procedure and the conclusions are sound. So if the initial judge had some important evidence and chose not to take note of it or didn't consider it properly or erred in process, the appeal judge can say, actually, you've got the decision wrong, you need to go back and do it again. But what they won't do is relook at everything from first principles again. And I think that's sort of the distinction to bear in mind here, in that unlike in a criminal trial, if you could appeal a conviction, the entire thing might be reconsidered at the appeal stage. But in this case, it's the Joint Senior Staffing Committee will have looked at it, will have made a decision, will be making recommendations to full council. Full council is entitled to say, actually, we don't think you follow the procedure correctly. We think you've made a fundamental error here. And the employee can make representations to that effect. What they shouldn't be doing is saying, let's go back to the very beginning and start this all over again from first principles. It's got to be, no, here's where we've got to in conclusions. Let's say whether we're happy with those conclusions or we're unhappy. I mean, and I think obviously, and presumably the ultimate appeal after that is still, people can still take it to import, even if they're dismissed by full council, they can still take it to employment tribunal in the end, even if they wanted to anyway. But I think that's probably the best way to think about it, is not in criminal terms, but in standard civil terms, I would suggest. And to me, that seems reasonable.
Thanks, George. Right. Today.
Just given that Councillor Potter was saying that one of the greatest causes of successful claims brought by staff against councils is delay, should we not then be putting in a timeline, even though I take your second order point that actually it's a bit difficult because you're dealing with third parties, but the first order point here is that to protect our taxpayers from unnecessary claims, we should be setting targets, and we could granulate it. We could say simple, medium, complex. Let's do the first in 2 weeks, the next in 4, the next in 2 months, or whatever. But at least set the targets for our taxpayers so that they can avoid unnecessary
lost cases. It seems to me we should be doing that. And one way in which we could do it is just do a quick bit of benchmarking on other councils.
Yes, Chairman, very happy to, take all the suggestions away and go and have a look and see what is possible in terms of setting some timescales, yeah.
May I make a proposal, I think, to just try to move us on to resolution on this item? Which is, I think that we've heard a variety of views on the point about timeliness and timetables and different views on that point. I think all of us, except we don't actually have a full legal position in front of us right now. The recommendation obviously is that we recommend that this is to be recommended to the councils for adoption. Perhaps what we could do is just simply say that we recommend, we would like officers to, we recommend this to go forward to full council, but between now and it going to full council, we ask officers to review wording on this topic and to come up with a proposal form of wording and potentially to circulate that to members of this committee for comment offline, so that we can sort of have a formal, so we can effectively have the final debate at council where this needs to be approved, but we do so with an updated form of wording, because I'm not sure we're necessarily able to say clearly what specifically we want, other than that we want something. That'd be my suggestion.
Gemma?
I think in principle that sounds like a really great idea, except it will be going to two different councils and we could end up with two different outcomes. Whereas if it comes back here to the joint committee, at least we'll try to have a concerted.
I think what I'm suggesting is that it should just be one proposal going forwards to each council. It does, so the same proposal going to each council. It just should, but effectively, if we approve it to go forwards, but with a request for officers to make some changes to the wording before it goes to full council, I mean, we've still got the same problem with that. One council could decide to approve it, one council could decide to refuse it, but that's true of any change we make. But I think also if it comes back to this committee offline, so we can review it and offer opinions on it, then hopefully it can be tidied up. But I'm also conscious in my mind, it's just that we probably don't want to leave this too long before it is passed by full council, because given we've scheduled things we've got, so I'd rather find a way to not disrupt the schedule while still making changes if possible. But that's just my suggestion. It may not be the right one, but that's just my suggestion.
Chairman, I mean, we could simply say that we'll review it and we will consult with the members of this committee. So we leave it as more of a consultation, which is obviously what we've been doing all the way along anyway. And then you can all feed your comments in, and ultimately officers will have to take a view on what is recommended to full council. But that might be the best way to do it, is just to consult or review and get your views. And I don't think we're going to stray very far from agreeing if we could get something in place. So
okay, I think we're happy, based on what you're saying, George, to go ahead in that way. Are you pretty clear now, Angela, on the areas that you wish to go away and think again about? I think that's fairly clear. Yeah.
Yes, I'm happy, Chairman. It is largely the issue of trying to get some timescales in there, subject to necessary caveats, really. So I'll go away and do some benchmarking, have a think about it, and yes, that's fine from my point of view.
So, do we need to change the introductory wording to the motion, in fact, that we're going to vote on?
Should we just get an indication that all members are happy with that approach, that I come back to you for some consultation comments on timescales? So that's sort of amendment to recommendation A, that you do wish to recommend the policy subject to insertion of some timescales, having consulted members of this committee. So otherwise, I think we can go through and take the recommendations, Chairman. Obviously noting that the one about the Waverley Appeals Panel is just for the Waverley members.
Yeah, that's a separate point, isn't it?
Yeah.
Okay, so in terms of the main motion, would you like to say what the introductory statement should be to all the items A to E, etc.? If we could have the introductory statement you're happy with.
Yes, I think if I understand, Chairman. So the report is asking members of the committee to vote on the recommendations on page 20 and 21,
Yeah.
noting that recommendation A has been amended to include the process of consulting members on timescales. So that the recommendations A, B, C, D and E are for the joint committee. But perhaps I'm just thinking before we do that, we ought to perhaps ask the Waverley members if they are happy to propose that the necessary amendment, which is just to Waverley's constitution, which is to remove the appeals panel provisions from Waverley's constitution.
Okay, well, let's take
Do you want
that
us
first
to do
from
that
the,
just
from
for
the
Waverley
Waverley
members
members.
first?
Michael?
It says here, remove the terms of reference. Well, that's not quite the same thing as removing the panel itself. Would we not be removing the panel if we're going to have a joint? Removing the terms of reference, we remove panel entirely. Then, of course, anything to do with it goes as well.
Yes, I think, Chairman, when we get to full council, Waverley full council, it will be that in effect they stand down the existing appeals panel, and then we'll be asking them to approve the terms of reference for the joint appeals panel. So,
If I may, just a point of terminology though, terms of reference is is basically the entire basis for any committee existing. So the terms of reference in the Constitution are the be all and end all of the existence of that committee. So I think when it talks about deleting the terms of reference, it's talking about deleting that committee. It means the same thing. Have I got that correct?
I would slightly disagree, Councillor Potter, in that I think you can appoint a panel, a committee or a panel without having terms of reference, and because ultimately committees can decide their terms of reference almost on the hoof, or their terms of their proceedings on the hoof. We don't ever recommend that. So I think technically you can have a committee appointed without having terms of reference, but that's the intention, is that we get rid of the Waverley appeals panel.
It's made very clear that we remove the appeals panel, full stop. And then it's quite clear to everybody what we're doing.
Are we all happy to agree to that? Yeah.
And sorry, Chairman, it goes without saying this is just your recommendation to full council. That's
Yeah.
it, yeah.
We will recommend that to the Waverley Full Council. We're all agreed. Okay.
Agreed.
In recommendation to both councils, Angela. So we're happy to agree these recommendations subject to the change that you read out.
Yes.
Yeah. Are we all happy to do that?
Agreed.
Agreed. Good.
Agreed.
Okay. So
And
we can now
Mr. Chairman,
move-
we'd have to make consequential amendments to the documents because 13.2 is now, needs to be changed.
Oh yes, that was an error that you picked up. Yes.
Yes, well, that's covered really by E. So
Yeah.
13.2 and I think it was, had another one which I've lost sight of now, 4.2 I think it was, wasn't it, on the, sorry, I'll just check for you, Jim. 4.6.1 of the OEPRs and 13.2 of the policy.
Okay.
Yeah.
Right, thank you. Well, I think that was a good discussion, and it's good to see that the members are so concerned about fairness arising from your initial points. Okay, so move on to item 8, which is proposed changes to the public speaking procedure rules. May I ask Deborah Davis, Joint Head of Governance, to introduce this item to the Joint Committee, please. Deborah.
Thank you, Chair. So at the moment, rules on public speaking are contained in 3 separate places in the Constitution. So you'll recall that we had a lengthy debate last year where the Planning Committee rules on public speaking were changed and they've been revised. And the council procedure rules are the same for both councils. But each council has a separate bit in their constitution as well that contains another set of public speaking procedure rules, along with the petition rules. I suspect it might just have been a hangover and that it wasn't deliberate that each council should have 2 different sets. But clearly the problem at the moment is it's very confusing because no one knows which set of rules should be applied. So I'm recommending, and JCRG have agreed with this, as have both leaders, that we actually move to just sticking to the council procedure rules that both councils agreed. They set out public speaking, and that we use those rules as well for all of our new joint committees, because at the moment there's no public speaking rules for joint committees. And that they are used for the executive as well. So that basically both councils will be using one set of rules in respect to public speaking, and those are the rules that are set out in the council procedure rules. So the slightly more random rules that don't that don't match with each other from both councils, that they should be removed from the constitutions, and that we do keep the petition scheme in, which formed part of that extra set of rules. So hopefully that's clear. It has been through the JCRG, who've both agreed that it's more sensible to just have the council procedure rules in place. I'm happy to take any questions though, Chair.
Deborah, I'm happy to propose that the Joint Standards Committee approves the recommendation in respect to this matter, which is set out on page 54 of our agenda. May I ask the other co-chair, Councillor Joanne Shaw, to second the motion?
Thank you. I second the motion and reserve my right.
Thank you. First of all, may I ask if any non-member of the Joint Committee from either council wishes to comment? Kimberly? No? Good. So we can move now to asking members of the committee if they wish to comment or to ask questions, please. George.
Well, just one comment. I mean, I think I'm quite happy with the proposed changes. I think they make sense. I think one thing I'd say is when it comes to supplementary questions from the public and response to them from the leader, mayor, or executive member, I'm not sure that 3 minutes is sufficient time. I'd suggest maybe 5 minutes if possible, because I think, and I mean, maybe for a supplementary question, you can get it in 3 minutes. But the number of issues where you can explain and answer fully, particularly if it's on a difficult topic, to take an example we had at Guildford recently, such as, say, investment in a company accused of complicity in genocide in Gaza, 3 minutes isn't much time to give a thorough response. And I think, I appreciate we have to have a cut-off somewhere, but I think 5 minutes rather than 3 would be preferable in my view. And obviously, we've still got an overall time limit of half an hour on public statements and questions anyway. But I think 5 minutes rather than 3 would be preferable in my view. But that's the only suggestion I'd make.
Any other comments on that point?
Thank you. Yes, I'm looking at page 74, part C, subsection 7, that there will be no public speaking on an application previously deferred by the committee, e.g. for a site visit. Now, I know that I spoke about this when it came up in Guildford, and we had a long debate, and we did agree that public speaking should be allowed if there was a deferment from a planning committee to the next meeting. And that doesn't seem to have gone through to this document. And given I'm in the property world and attend numerous planning committees, it's something that I have a personal vested interest in. And I just think it's wrong. If you were entitled to speak at the first meeting and then it's subsequently deferred, you should be able to speak at the second.
Deborah, to comment on both of these points.
Yes, thank you. So if I can help, so you've really just hit the nail on the head, Mr. Litvak, that the planning speaking rules are contained elsewhere in the Constitution, but it's muddled by the fact that bits of old rules are sitting under this part as well. So members of the Standards Committee agreed a new set of public speaking rules in respect of planning last year, but there's still odd bits that sit in this part as well as other bits in relation to public speaking. And that's the reason for the report, is we really don't want to be having different bits of public speaking in various bits of the Constitution, because no one really knows where they're supposed to be looking for what they are or aren't able to do.
That doesn't answer the question, unfortunately. There was a debate, and I know that I brought up this very comment, and it was a long debate, and we agreed that people would be able to speak at a deferment.
So what I'm saying to you is that these are not the public speaking rules in relation to planning. These are public speaking rules. There is another set of public speaking rules in relation to planning in the Constitution that were agreed by the Standards Committee about 6 months ago, I think. Actually, Angela Watson might be able to help a bit more because she did those rules, so she might know when they were taken through. But this is not the up-to-date set that the committee agreed.
So long as I have the right to speak for a deferment, I'm happy. I don't care where it's contained.
I'm the clerk for planning. So basically, these rules are what we're recommending, that they're not going to be there anymore, the ones that you've got in this document. There are a set in the constitution of both committees under planning that set out the rules, and they are that you can have 2 objectors, 2 supporters, that you can speak on a deferred item. Okay, that's basically it. Is if the ones that are set out in here, forget them. Does that make sense? Lovely.
Thanks for that, Kimberly. Deborah, how about Councillor Porter George's earlier comment on the 3 minutes as opposed to 5 minutes?
That's a matter for members, Chair. I mean, clearly the JCRG were happy with the 3 minutes, but it's a matter for members of the committee if you want to recommend longer to the full council.
What do other members of the committee feel about that?
Yeah, I was going to say that I think public speaking and public speaking procedurals is something which is actually really important, because I think, you know, the sort of public accountability and the capacity of the public to actually properly engage with the council is something which is really, really important. And, you know, where I see that being kind of marginalized, I personally get very worried, even if I sometimes find it tiresome, but I think it's very important. And that's why I would agree with Councillor Potter's point with regard to the timescale. What I did also want to raise, and in a sense I sort of raise it as a question, because I think, you know, for concerned members of the public who take the trouble to sort of ask a public question or come along to a council meeting, actually, you know, deserve to be able to speak on any issue which affects the borough and on which the borough, you know, on which the borough councils should really be able to express a view. And therefore, I am a little confused when it talks about subject of public questions, because it refers to matters which affect the borough / council's powers and duties. Is that either or both? In other words, or you know, is it one or the other, or is it both? I mean, I think, you know, we do need to be able to enable the public to be able to speak on any issue which affects the public in the area that we cover. So, you know, any matters which affect the borough would certainly be my preference, and that would subsume matters over which the council has powers and duties, but it would go beyond that.
Have you any comments, Deborah and Steve's comments?
So I think that Councillor Williams is talking about 11.2, which is the grounds for refusal, which is if it does not relate to a matter for which the council has responsibility, or does not affect the borough. So I think that that both councils exercise a really wide discretion in relation to this, and if it, you know, even if it tenuously affects residents, then you do allow questions on the full council agenda, even if the council themselves can't do anything about it. So I hope that helps you, but I do see your point about it's not necessarily exactly clear. So I will go away and have a look at that wording and make sure that I give it a bit of a tweak to make it as clear as possible. Because I think the intention is that if residents feel it affects them, even if the council can't do anything about it, then it's appropriate that it gets aired at full council.
Thank you. I mean, that actually covers the point I was making, and I'm grateful for the clarification, but I do think it needs to be explicit in the wording. Thanks.
Peter?
Thank you. I would prefer 3 minutes. I think if you marshal your thoughts and you make notes, and I think you can get your points over in that time. I mean, I've heard a number of councillors over the years where they've obviously timed themselves to speak for 4 minutes. They made their point in 2.5 minutes. The rest is sheer padding. So 3 minutes is perfectly acceptable. Thank you.
What do other members of the committee feel about that? George, you want to come back?
Yeah, I think normally speaking, 3 minutes is fine, but I think we need to consider. I mean, first of all, we're talking here about members of the public who are not experienced public speakers in a lot of cases. It can take time to articulate your point, particularly to do it within a time scale. 3 minutes is not long. Similarly, if somebody asks a question on a complicated topic, it can take more than 3 minutes just to give a basic summary of the facts. I'd also point out that in a typical council debate on a motion, we allow councillors 5 minutes to speak in the debate. Doesn't mean people have to use the 5 minutes, but I think I've seen a number of occasions where public speakers, or for that matter, executive members, have had to draw their remarks to a close at the 3 minute mark, when actually for the sake of 30 seconds or 45 seconds, they could finish their point. And I don't see how that really helps cause a public debate. And I think particularly when this is one of the only ways in which members of the public can speak at council, I would much rather err on the side of giving them a bit too much time and perhaps occasionally having to sit through a speech that is too long than to on the side of just keeping it as short as possible. I mean, you know, and again, I certainly think it doesn't make sense for us to hold members of the public to a higher standard for succinctness and brevity than we're willing to hold ourselves as councillors in the full council debates. I just think that would be a really bad look.
Can I just be clear? Are you suggesting in terms of all occasions in which the public are able to speak at planning committees or full council meetings or any other occasions?
Well, no, Chair, because we have just heard that this does not apply to planning committees. I mean, in any event, I think planning committee already is 5 minutes anyway, if my way of the new rules, but it doesn't matter. But these rules are talking about non-planning context, and I think in non-planning context, we should allow people 5 minutes, which is the same amount of time we allow ourselves in a full council debate.
So you're talking about any non-planning meeting, your recommendation is it should be 5 minutes. Okay. What do other people feel?
I'm laid back about it and I'm happy for 5.
Oh, right. I agree with the councillor over there. 3 minutes is plenty.
I find myself persuaded by Councillor Potter's point about the fact that this is members of the public and we can't expect them to be as practiced in public speaking as people who do it all the time. And I think from that point of view, we should give them the benefit of a bit of extra leeway.
Yes, just to talk about that point, I notice when members of the public come, they always come with prepared, with everything written down. Very rarely do you find members of the public humming and hawing and not sure what they're saying. They're possibly a little nervous. They want to get it right, so it's all written down, and usually they get it down in that time. So I stick with 3. I might compromise with 4, but I don't like 5. Thank you.
I find myself agreeing with Councillor Potter. You know, I think people are coming, they're making the effort. We should listen and come on. What's 2 minutes? In the course of a meeting, if it means that they're going to get a point across without rushing it and expanding on what concerns them, I'm 5 minutes.
Yes.
I agree with Councillor Potter. I think it's not always people come with their pre-written notes and read them off word for word. They're quite passionate about their causes and they go off a bit, you know, with important points. And I think it's fair to give them 5 minutes.
Okay. Well, let please come in.
Is that for me?
Yes, for you, yeah.
Excellent. Yes, I think Councillor Potter's point is very valid that some things may require more depth. I think most of the time 3 minutes would be fine, but for something serious, perhaps 4 or 5, perhaps a compromise on 4 minutes. Thank you.
Okay. Well,
Chair, could I ask you to please use your microphone because we couldn't quite hear you then.
sorry, I think I had put my microphone, but let me say it again. Let's have a vote on Councillor Potter's proposal for 5 minutes as opposed to the current 3 minutes. Everyone who supports that. Well, that's a clear majority, actually. So the committee is recommending that we go to 5 minutes then.
Chair, could I just be clear? Is that for the member to reply as well as the person asking the supplementary question or making the supplementary statement?
I originally suggested both. I mean, I think it doesn't make sense to give one longer than the other.
Yeah.
But yeah.
I think we're saying both, yes. Yes.
Thank you.
Okay. Right.
We can't hear you in the chamber.
Sorry, I do apologise. I didn't put my microphone on there. The Joint Standards Committee will now move to vote to the motion to vote on the motion to approve the recommendation to each full council in respect of this matter, which is set out on page 54 of the agenda. So is that agreed?
Agreed.
Agreed. Thank you. Sorry, getting bad at that. We now move to item 9, strengthening the standards and conduct framework. May I ask Faith to introduce this item to the Joint Committee? Faith, can you introduce the item, please?
Yes, thank you so much. So the report in front of the committee informs the Joint Standards Committee about the the Ministry of Housing, Communities and Local Government has published a formal response to the national consultation on strengthening the standards and conduct framework for local authorities in England. They sought views from councillors, officers, professional bodies, community representatives and members of the public, and sets out quite an extensive package of reforms. These are intended to strengthen standards arrangement across local government and address some of the long-standing weaknesses in existing frameworks that were introduced with the Localism Act, specifically in terms of right of appeal and sanctions for any misconduct. The full set of the recommendations or the proposed recommendations are set out in paragraph 6.3. There's some of the main ones. I'm just going to rattle through them. They're recommending a mandatory national code of conduct. This will be introduced by legislation, and it'll be based on the 7 principles of public life, the Nolan principles. And in both Guildford and Waverley, we currently adopt the Local Government Association Model Code, which already aligns with those 7 principles, but we'll need to review and update once we get the full publication of the Ministry Code, that once it's published. There'll also be mandatory training that will be required for members to make sure that we're complying with the new statutory requirements. The other recommendation proposed by the Ministry is a formal standards committee for all principal authorities, which West Surrey will be. And for example, we are in a good position because both Guildford and Waverley already have a joint standards committee. They have which meets the structural requirements that's been proposed by the government. They will require some revisions of the terms of reference just to make sure that we're in alignment with the statutory functions. There'll be new requirements in oversight of suspensions. There'll be additional sanctions, and these will need to be incorporated once we know what the legislative requirements are. The other recommendation is publication of outcomes and monitoring completion of all investigations. So our current standards arrangements allow the monitoring officer at the discretion to close a complaint. For example, if a councillor resigns and is no longer a member, the government proposal is that regardless of the status of the councillor, that position would have to be concluded. The investigation must go to an end. But there will be, some changes in relation to our confidentiality reduction. Timing of the protocols will need to be updated and aligned once we get the legislative instrument. There's also a new requirement that there should be support for complainants and respondents in a right of review. This is currently not set out either in the LGA code nor in our current arrangements. So we don't have a statutory right of review when we present a code of conduct complaint. And if we have so we will require a formal support process to be put in place. And it won't just be to support the member who's subject to the complaint, but also the complainant so that they can understand the process. But it will also have an option for members to appeal against any sanctions that the Standards Committee put forward. That's something new. There's also going to be statutory sanctions. These are new as well. You can have suspension, withholding allowances, ban of premises, interim suspension, disqualification will be the major one. Our current arrangements, they're non-statutory. They include censure, training, removing from a committee, access restrictions, asking members to apologize. But the council will need to make amendments once we have the full legislative instrument. And the final one, which is going to be probably the biggest change, there'll be a national appeals function. So it'll be a new national appeals mechanism. It'll allow councillors and complainants to appeal the decision if they're not happy with the local decision. The response doesn't actually set out how this is going to happen or what the process is. So we're just going to have to wait and see what the ministry produces. So a copy of the actual consultation outcome is attached as Appendix 1, and I'm happy to take any questions or comments from the committee. Thank you.
Thank you, Faith. I'm happy to propose that the Joint Standards Committee approves the recommendation in respect of this matter, which is set out on page 85 of our agenda. May I ask the other co-chair, Councillor Joanne Shaw, to second the motion, please?
Thank you. Yes, I second the motion and reserve my right.
Thank you. May I now ask whether any non-member of the Joint Committee from either council wishes to comment or to ask a question in relation to this item? No? Thank you. So we now move to asking members of the committee if they wish to ask questions or make comments, please. Michael.
Chairman, I welcome this because I think for those of us who've been on the council a long time, we did have powers once and then they were all taken away. And now they're going to be put back. This is for the outcomes. All you could do now is rap them on the, on the knuckle and say you've been a naughty boy or girl. But it's bringing back sanctions that we used to have. And sitting on the appeal of standards panel, as I have for Waverley for years, it is very frustrating after a day or 2 days of hearing to then find that the person has actually erred in their conduct, and all we can do is tell them that they mustn't do it again. So I think it's a good idea, and I think the appeals to nationally, from memory, I think we had that going back a few years too. So I think this is a move in the right direction, and let's wait and see what comes, and we'll have to amend our constitution to comply.
Peter.
No, I agree with Michael on that one. It's nice to have proper sanctions now. But I'd like to thank our monitoring officer for actually giving us early sight of this. And it's always welcome to see what's in the pipeline. Even though the timing isn't known, it's very useful. We can see what action we can take in the future. And I do welcome strengthening the legislation and agree with all recommendations. And a national code is important. And an insult in Brighton is no less than the one in Bradford. It ends a legal postcode lottery. So I'm all for this extra document.
Bob.
Thank you, Chairman. Just 2 points. I agree with this report and I'm happy with it. Just 2 things. One, on page 87, support for complainants and respondents and right to review. I think that's absolutely vital that is in there. I think my view about what comes forward when we get the full report is going to depend on what that support is. What it can't do is to come from within the council officers. And there was a hint somewhere I saw in here that might be the case. That wouldn't be appropriate. It would have to be external. I recognise there's a cost to that, but if it gets to the stage of a hearing, then I think that's deserved. Secondly, I think I'm right in saying that most of the complaints we get are in relation to parish councillors. And I do know of a case, and I don't know whether this is usually the case or not, but one complaint against a parish councillor that I know about. He wasn't allowed to know who made the complaint. He wasn't allowed to know what the complaint was. And frankly, the communication with him was frankly insultingly sparse. So I will want to be reassured at that point how that actual process is going to work, because it's rather Eastern European to not be able to know what the charges are against you.
And very unfair. I don't know if Faith would like to comment on that before we move on. Have any comment on that point, Faith?
Yes, just to clarify that this is a draft. These are draft proposals, so we will be waiting for the actual legislation and a confirmation of the implementation timetable for us to be able to bring forward what those, whether it's the support for complainants or the right to appeal, what that needs to look like. In relation to the right of anyone who is currently subject to a complaint, there is a complainant can make a request to the monitoring officer for confidentiality. And if it's right to do so, then that information, that would be the reason why a subject member would not be told who's complained, but they would be told what the complaint is about. We would never undertake a complaint where at least that information is not provided. But Deborah, head of governance, probably might want to also add something on that particular point.
Yes, if I could just jump in on that, we do have a duty sometimes to keep complainants confidential. And that is particularly the case, if I could say, in the instance, as an example, of the parish clerk. who may be fearing for their employment. So if they make a complaint about a parish councillor, so it may very well be that we don't disclose who the complainant is, but we have always disclosed the nature of the complaint to all complainants, and that's part of the council's agreed standards arrangements.
Yes, I absolutely accept that point, except in the case I'm talking about, he didn't even know what the complaint was. Actually, he did, and he knew who'd made it because everybody local knew who'd made it and why. But I won't go further than that.
John, do you think you had a comment?
Yes, a couple of comments. I mean, I think I also welcome this, and I think this is one of the few areas where I think national standardisation is helpful to local government rather than detrimental. Because certainly I think what you will find is that standards regimes and the way in which they operate are different in every single council and even different in the same council between different monitoring officers when one monitoring officer leaves and is replaced by another. Certainly at Guildford, I found that under different monitoring officers, there have been very different approaches taken to the handling of complaints, even though the rules have theoretically stayed the same. And some have been quite diligent and some have perhaps been less so. But I think what's particularly going to be particularly helpful is to have a much more robust set of sanctions open. I think one thing that I found deeply disappointing in my time on Guildford Council was not under the current council, but under the previous council. The Conservative group leader had numerous complaints upheld against him for bullying and for disrespectful behaviour. We applied the ultimate sanction we could, which was to censure him, but which of course had no impact. And of course, the only real sanction we had was potentially to refuse his permission to use council facilities. But all that would have done was end up resulting in punishing his residents for having him as a councillor, not doing anything to actually deter the behaviour. So I think having a regime with real sanctions, but also one where there's an external robust right of repeal, which gives people cover against vexatious or politically motivated or mishandled complaints, etc., I think is very welcome and will improve the standard of conduct in local government across the board. I think, but yeah, as you say, I mean, obviously this report is just simply to let us know that this is coming down the line. So I guess all we can do is wait and see what happens. But I do think it is probably to be very much welcomed.
Thank you for that. Any other comments? Yes.
Thank you. I took great personal pleasure in reading this report. I've been involved in standards since 2000. I've lived it and breathed it in, this is my third council and I'm still involved with another one. I would make some observations because I was one of the first chairmen appointed in the country, so I've lived through the revisions and the changes and the dilutions. First of all, on page 87, support for claimants and respondents. Certainly in the local authority where I am the independent person, both the complainant and the defendant, as I would describe them, do have the ability to contact me and speak to me, and I can offer unfettered comment, advice, suggestions, obviously with the Chinese wall if necessary, if both parties have contacted me. So that sort of exists. I fully appreciate it might not be universally, but it does happen already. Then on page 88, yes, we've basically gone back to, I don't know, 2015, 2016, when suspensions, removing people from the premises, taking away computers was perfectly allowable. So it did become a toothless tiger. Then on page 102, we'll get to this, honestly. 102. What was this in response? This was in relation to voting rights. The independent people sitting on the committee should have a voting right. Guildford members will know that I've banged on about this long and hard since my involvement with Guildford. I come along with Julia. We can speak, we can try and influence, but at the end of the day, we can't vote. Even if we lose the vote, at least we've been able to exercise democracy. I come along to every meeting and I can't put my hand up. It feels wrong. So I'm delighted that that is now being encouraged. Then on to page 122. Get to it, obviously. Again, 68% of respondents agreed with me that the independent people should be allowed to vote. So again, I've only voiced what the public feel is sensible. And then finally on 123, page 123, Standards Committee should be chaired by an independent person. Certainly in Spelthorne, I was the chairman for 20 years and I was independent, and we didn't need votes because we discussed and we negotiated until we came to an agreement. But I was always there along with my deputy chairman, who was also independent. We could offer the view of the man on the Clapham omnibus because we were unfettered by political niceties. We didn't need to worry about friendships. We were there to speak up to ensure that members didn't err. We wanted to educate them. We wanted to work with them. Some of the other things I would make a general comment on. The standard boards of England, when it existed, was quite frankly a nightmare. It was a millstone round your neck. I certainly attended one meeting when the complaint was regarded as so serious that we couldn't deal with it. So serious that we couldn't hand out 6-month suspension. And we attended the meeting, full day's meeting, lots of expense to everybody concerned. And the individual got a slap on the wrist, and the monitoring officer and I looked at each other and said, well, if he'd appeared before us, he would have had a suspension. The standards board were very weak. They were totally inconsistent. They regularly published cases, and you couldn't even read any consistency from the cases that published. So I would just put a little bit of a watchword that that may not be the answer to everybody's hopes. I hope this comes to fruition. The detail will obviously, the devil will be in the detail.
Any comments from anybody else? Okay. Is anything you want to come back on, Faith, actually having heard the comments of the various members of the committee before we go to the recommendation?
I'll need to say these are draft measures at the moment. This is the plan of the ministry, so we'll wait to see what the full details are, and we'll be bringing a report as and when we receive the various draft legislations and regulations.
Okay. Thank you for that, Faith. So it sounds as if we're pretty agreed in that. We all broadly agree with Michael's original comment that this is a far better way forward than the current situation. So in that case, the Joint Standards Committee will now move to vote to the motion to approve the recommendation in respect to the matter, which is set out on page 85 of our agenda. Is that agreed?
Agreed.
Agreed.
Great, thank you. I don't think there's any other items. Sorry?
No, it's just.
Yeah, thank you. I don't think there's any other items of business. So thank you for attending and look forward to seeing you at the next meeting. Thank you.
Have a good evening all.